Hi there. I'm Julia Horrocks. I'm one of the managing attorneys at Pisgah Legal Services. Today, I'm going to address some of the common questions we are getting from survivors of domestic and sexual violence during the COVID-19 pandemic. I've been practicing domestic violence law and family law for 8 years. Though this is not a live chat, please feel free to submit questions to our Facebook Messenger page, and we will address them if we can. Note that we cannot provide case-specific advice on this forum, and we discourage anyone from submitting confidential information on social media. We know that this is a particularly difficult time for survivors. While many people are instructed to stay at home for their safety, home can be unsafe for someone facing domestic violence, and access to the courts and other services can be especially challenging during this time. We provide free civil legal services for survivors who are income eligible. If you or someone you know is experiencing domestic or sexual violence, you can contact us at 828-253-0406 or apply online. The application is available on our website at pisgahlegal.org in both English and Spanish. We are grateful that many of our partner organizations, including all of the domestic and sexual violence shelters and service providers in our region, remain open to provide shelter and remote services as best as they can. We encourage you to reach out to your local domestic violence agency if you could use support. Note that the advice that I'm sharing today is broad and is not county specific. Each court system may address particular cases differently, but I have taken into account what we've seen in the 11 county region that we serve in Western North Carolina generally. The first topic I'll address is filing for protection orders. Though many court cases are not being heard right now, one of the main exceptions to that rule is that survivors of domestic or sexual violence can still file a complaint for a protection order. When granted, civil protection orders prohibit an abuser from contacting or threatening someone for up to a year. They can require an abuser to stay a certain distance from someone, relocate out of the household, prohibit them from carrying firearms, determine temporary child custody arrangements, and provide other safety measures. People can also request temporary orders that would be effective immediately until the hearing date. In some counties, judges are less available than normal for these hearings during the pandemic. We encourage survivors to contact the clerk of court in advance to determine the hours of operation. If a judge is not available right away, you can file with a magistrate. And if you are unsure where to go, you should contact your local law enforcement to ask what the current protocol is in your area. In some counties, your hearing may be continued out for a week or more. Keep track of your court date and contact the clerk of court in your county if you are unsure about your court date. We've also had questions about attending protection order hearings. If you have already filed for a protection order, you still need to go to court during the stay-at-home order, unless you are directly told by the court, not anyone else, that your case is continued to a new date. Domestic violence protection order hearings are still being heard by the courts in all of the counties in our service area, and our attorneys are representing survivors in those hearings. Both the plaintiff and defendant are still required to attend. If you miss a court date, it is very possible that your case will be dismissed, even while the stay-at-home order is in effect. Some counties, including Mitchell County, are holding hearings via video conference in certain cases. If you have a medical condition that puts you at serious risk, or if you plan not to attend court because of concern for exposure, your case might still be dismissed if you fail to appear. If you choose not to attend or are unable, we strongly suggest that you let the clerk of court for the domestic violence cases in your county know. While there's absolutely no guarantee that your case will be continued to a later date, it might be more likely to be continued with a written request. So if you need to notify the clerk that you will not be there, we suggest you do so in writing, such as in an email, or file a motion to continue the case. State that you are requesting a continuance, and provide the medical or other compelling reason that you are seeking a continuance. It is always advisable to communicate with an attorney before communicating directly with the court if you can. Do not wait until the last minute. Make any request for a continuance at least a few days in advance. The clerks are being inundated with phone calls from people about their cases, and it may take them a couple days to process your request. Until you hear a response, you should plan to attend court when it is originally scheduled in order to avoid a dismissal. We also suggest that you include a safe phone number to contact you and to be ready to attend court on time if you do not have a response or if you are instructed to do so. Many domestic violence survivors are also litigating custody or divorce cases, so that's the next topic I'll discuss. For survivors with pending custody or divorce cases, your case might be continued during the stay-at-home order. Might is the key word there. Most family court cases are being continued for a couple months. However, some cases are still being heard, and you should not assume that your case is being continued during the stay-at-home order. If you are unsure of your court date, verify with the family court clerk or your attorney to confirm the date of any pending case. Again, do not wait until the last minute. Some of the case types that are still being heard include emergency cases, orders that are due to family court judges, phone conferences with just the attorneys, or other cases as judges deem appropriate. Unless you have an emergency, new custody complaints are also not likely to be heard at this time. Emergencies include cases where there is a substantial risk of bodily injury to or sexual assault of a child, or substantial risk of removal from the state of that child. If you have a custody order that directs you to exchange custody of your child or children with the other parent, you should exchange custody and otherwise follow the order even while the stay-at-home order is in effect. You are still required to follow court orders to the extent possible under the rules. During any custody exchange, it's advisable to exercise social distancing of 6 feet or more, sanitizing, and taking other precautions to reduce risk. This is also true during your custodial time. If there is a serious risk to you or another's safety, that is, if someone has symptoms of coronavirus or has been diagnosed, and you feel unsafe doing a custody exchange, you should notify your attorney or the other party. Fear of contracting the coronavirus when neither of the parties has symptoms is not likely itself to be a sufficient argument in defense of failing to follow a court order. Keep in mind that failing to follow a court order could be a factor in a court's analysis of what is in the best interest of the child during future litigation. If you and the other party agree to alternate terms of your order during the epidemic, it is advisable to secure the terms of that agreement in writing. Note that the Family Visitation Program at the Mediation Center is planning to offer supervised visitations by video conference in some cases. And there may be other similar resources for those whose orders require supervised visitations. Child support and income security is another topic of concern for many survivors. The bottom line is to plan as best as you can for the fact that many people are losing their jobs. And even with the stimulus checks, it may be harder to pay the bills for a while. It will likely be a number of months before we really see the effect of this pandemic on household income. Many people will be eligible for unemployment benefits, but incomes are still likely to decrease. Under the CARES Act, if one parent is behind in child support payments, their stimulus check may be garnished to cover that debt. Though that can be helpful for the parent receiving support temporarily, many folks may experience job loss or job reduction for a significant period of time, and it's likely that many parents' ability to pay child support in the long run will be affected. Whether you are considering leaving an abuser or already have, you may want to consider making an emergency plan for what you will do if your income significantly decreases. Your local domestic violence agency can counsel you on making such a plan for your safety. That ends the questions we have. We hope this has been useful. If you have additional questions, we can answer those again on our Facebook Messenger page. Pisgah Legal Services attorneys are available to advise eligible applicants on protection order and family law matters where there's been a history of domestic violence, sexual assault, or child maltreatment. Again, if that might apply to you, contact us for free advice at 828-253-0406 or apply online at pisgahlegal.org. You can also contact North Carolina's Lawyer Referral Service Program for a referral to an appropriate attorney at 1-800-662-7660. And if you haven't already, you might want to take a look at our other Facebook videos on COVID-19 specific information on unemployment benefits, tenant rights, and health insurance. Thanks, and stay safe.